Be your moderator today. Welcome to the Physical Therapy Board of California board meeting.
Hi, good morning. I'd like to call this meeting to order. The time is 9:08. Today is Thursday, September 16th, 2021. This is a one-day meeting of the Physical Therapy Board of California, and today we are meeting virtually by WebEx. This is an official business meeting of the Physical Therapy Board of California. The board's role during the pandemic continues to be to maintain consumer protection and consult with local and state entities on the laws and regulations pertaining to the physical therapy industry. I would also like to explain how this meeting will be conducted. We do have a moderator from the Department of Consumer Affairs online to help us today, and that's David. Individuals listening to the meeting will have an opportunity to provide public comment and will be assisted by a moderator who will be facilitating the teleconferencing process. That will be David again. We'll take public comment on specific agenda items. At both the beginning and end of the meeting, there will be a comment section for items not on the agenda. Public comments must be specific to the agenda item that's being discussed. If you make a comment during a specific agenda item that's not related to the topic, you will be placed on mute by the moderator. All comments that do not directly relate to an item on the agenda should be held until the agenda item for items not on the agenda. The moderator will give you instructions on how to make a public comment and how to raise and lower your hand. The board follows the Open Meeting Act, so while we accept and appreciate the public's comments, we cannot respond to those comments. For those members of the public participating via teleconference, please wait until the moderator has introduced you before you make your comment. The moderator will give instructions on how to participate at each opportunity for public comment. This meeting is being recorded and minutes of the meeting will be prepared. Can we please have roll call?
Alicia Rabene-Amen.
Here.
Katerina Ellaby.
Here.
Dale Armstrong.
Here.
Jesus Dominguez.
Present.
Daniel Drummer. Daniel Drummer is absent. Jonathan Irvin. Jonathan Irvin.
Here, but it's muted, I think.
I'm present.
Thank you. Tanya McMillian.
I am present. Can you hear me?
Yes, thank you.
Great.
Tanya McMillian.
She's present, but she's muted.
All members are present with the exception of Daniel Drummer, and the board has a quorum.
Thank you, Brooke. Is there a way to tell that Tanya is active even though she's muted? Ms. McMillian.
She's with us, but she's having a hard time unmuting.
Okay. Thank you. All right, and if I could call on Dr. Jesus Dominguez to please read our board's mission statement.
Certainly, Madam President. The mission of the Physical Therapy Board of California is to advance and protect the interests of the people of California by the effective administration of the Physical Therapy Practice Act.
Thank you. And agenda item number 4 is public comment on items not on the agenda. Moderator, will you please open public comment?
Just one moment, please. All right. Comments are now open, or it is now open for public comment. If you'd like to make a comment, you may type a comment into the Q&A box, or you may raise your hand. Seeing no comments, would you like me to close the Q&A box?
Yes, I think let's just pause maybe another 30 seconds in case someone's having difficulty navigating the technology.
Absolutely.
Okay, I think we can close public comment, David. Thank you.
Comments are now closed.
Thank you. Okay, before we get to agenda item number 5, I just want to check in with Ms. McMillian and see if she is able to unmute just yet. I'm just a little concerned. I do want her participation, and
she's setting a call in, so she's having issues with her computer, but she's going to try to use the phone in line. So we should be seeing her coming online very shortly.
okay. I see a calling user.
I believe the calling user has their hands up as well.
How do we address that?
This is the moderator. I've sent a request for Tanya to unmute her mic. Hopefully that can assist.
Can we promote that calling user to be a participant? That might be the issue. That's an attendee.
David, I do see a calling user in the queue with their hand raised. That may be Tanya, or that may be a member of the public. Can you check either way?
I have sent a request to unmute the mic.
Yes, that's me raising my hand. I had to call in.
Wonderful. Let me promote you. Hold on just a moment, please. All right, you've been added to the panelists.
Wonderful. Thank you. Welcome aboard, Ms. McMillian. Okay, we're going to move forward on agenda item number 5, which is review and approval of the June 24th, 2021 meeting minutes.
The meeting minutes begin on page 11 of the meeting materials. I'll go ahead and go through page by page to see if the members had any edits or changes. Were there any changes on page 11? Page 12. Page 13. Page 14.
Yes, I have a correction. This is Dale Armstrong. Page 14, lines 143 through 144, take out the her. I believe it should read, Mr. Kaiser also reported that Miss Pearl and slash the her after that has been appointed to the office technician typing position.
Thank you. Make that change. Were there any further changes on page 14? Page 15?
On page 15, under CDE or CD, those might have just been, referred to the report that will be forthcoming. But I'm wondering if we might want to make a note of that here, because it almost looks like something could have been left out, maybe.
Yes, of course. I'll go ahead and add a sentence there clarifying that it was directed to go to the agenda item. Thank you. Any additional edits on page 15? Moving on to page 16.
Page 16, I am wondering if members of the public were to look at this page, if it were to be helpful to at least include the date for the most recent extension. And I'm open to discussion from other board members, but I'm just thinking, I'm wondering how the public might decipher this particular agenda item and make sense of it. Any other board comments on that? I'm going to wait until one of you unmutes and says something.
Well, although I'm not included in that list of unmuting, we will make it a little bit more easy for the public to digest with our discussion today. And so we'll record it in the minutes and capture it that way.
Okay. That's my comment.
Okay, any additional edits on page 16? Moving on to page 17. Page 18. Page 19. Page 20. Page 21. Page 22. Page 23. Page 24. Page 25. Page 26. Page 27. Page 28. Page 29. Page 30. And that concludes the meeting minutes for June 2021. Okay.
Any further board discussion on the minutes? I move to approve the June minutes 2021 as amended.
I will second.
A motion by myself, Alicia Amon, and a second by Katarina Ellaby.
Dale Armstrong.
Oh, sorry, was that Katarina?
Dale Armstrong.
Oh, that was Dale. Sorry, Dale. That is
Nope.
second by Dale Armstrong. Okay, and if the moderator could please open for public comment. Hello, moderator. Are you there to facilitate public comment for us?
My apologies. I was speaking and my microphone was on mute. Public comments are now available. If you would like to make a comment, please type comment into the comment box and/or raise your hand. Seeing no comments, would you like me to close the option?
Yes, please, thank you. Okay, again, we have a motion by myself and a second by Dr. Dale Armstrong. Can we have a roll call vote, please?
Alicia Ben-Amen.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer. Daniel Drummer is absent. Katarina Ellaby.
Aye.
Jonathan Urban.
Aye.
Thank you. Tanya McMillian. Tanya McMillian.
Aye.
Thank you. 6-0, motion carries.
Thank you. Okay, agenda item number 6. This report, let's look at the 2021 adopted meeting calendar. So here we are in September 2021. And we've got some dates coming up in December. Any board comment on the the 2021 adopted calendar?
Just a point to make from staff. Like many things in this global pandemic, we're getting things a little out of sequence. So on Tuesday of this week, we received the sunset template from the legislature. So I think now is the time for us to schedule a 1 or 2 day session, probably latter October, and then maybe again also for November, to finalize in December's board meeting for a report that is now due January 5th of next year. Because of the recency of the template, staff suggests the 3rd week of October and the 3rd week of November as well, which is the week before the Thanksgiving holiday. So as an example, 20 and 21 of October and 17 and 18 of November.
So October, 3rd week in October, the latter part of the week, I will be at a conference. So the beginning of the week or the 2nd week in October works well, or the last week in October works well. Other board members for October?
Madam President. Oops,
Yes.
sorry. This is Jesus. So my teaching load is pretty heavy Monday through Wednesday. So regardless of the week, just to let folks know. Thank you.
Thank you. Does the 2nd or the 4th week work for you?
If correct, if it's Thursday or Friday.
Okay.
And so as an example, that we could also offer that as an alternative to October 28th and 29th.
I have meetings both those days. This is Michael Canocha, counsel.
And you have a conflict 21st and 22nd? First week of November, 4th, 5th?
I have a meeting conflict on the 5th of November.
so you can do the 4th.
Correct.
And it's Monday meetings, they would be a late-hour meeting. And it's not a normal board meeting. We don't have other agenda items. It's just like specifically the development of some support, classroom setting, very casual, come in, roll your sleeves up, work kind of thing. So, and I'll take what I can get.
Yeah.
For the October 28th and 29th, there's a conflict with both dates, 28th and 29th?
Correct.
14th, 15th?
How about the other members?
I have a conflict on the morning of the 14th, October 14th.
So, I mean, I could propose October 15th, which is a Friday, and then again November 4th, which is a Thursday. Having those 2 days, you know, maybe after the first time that we meet, we can gauge if there's another date in November that we need to add. We have a little bit of time during the December month without trying to get too close to the holidays. If we needed to add an additional date, we could. And I think, you know, for those board members that were with us in the last sunset report, I don't know that this particular sunset report is going to be as laborsome or as time-consuming. The template, the majority of the template is staff-driven. What we would be looking at is addressing issues previously identified in sunset reports and what we've done. Specific questions regarding COVID-19 and how the board has performed during COVID-19. An example of that would be the waivers that were issued for PTs and PTAs, those kind of things. And then any new issues that the board would like to have addressed in legislation during the sunset process. So it's as complicated as we make it to a certain extent. But I think, you know, single day October, single day November, potentially a second single day in November, and even a single day in December would be plenty of bandwidth. So right now it sounds like there aren't any calendar conflicts for October 14th or November 5th.
I think Dr. Armstrong.
Oh, Dr. Armstrong had a morning issue. Okay.
This is Katerina. I'm available both of those days.
Thank you, Katerina.
Friday the 8th.
Mr. Executive Officer, very quickly, sir. I'm losing track of the months that we're in. Are we still Friday the 8th? Is that November or October?
October.
Okay, thank you. I'll take a quick look.
Quick turnaround time.
This is Michael. I have a meeting that day, a board meeting. Were we looking at the 15th of October?
But I believe there was a conflict. No? No conflict on the 15th?
No.
So for clarification with all members, October 15th, a Friday, and November 5th, a Friday.
I have a conflict on the 5th. I thought we were looking at the 4th.
Both of those days work for me. This is Tanya.
What about November 4th?
That works for me as well.
So currently October 15th, a Friday, November 4th, a Thursday, and depending on how those meetings go, we could, after the 15th, gauge whether or not a second November or a second December meeting would be necessary.
Yep. Sounds good. Will those meetings be in person, virtual, or to be determined?
Those meetings can be in person, and I'd prefer them to be that way.
Okay.
Does that change anything for the members as far as availability?
No, sir. I'll pack my bags.
Let me check, and this will be in Sacramento, correct, Jason?
Correct. And we would have you travel in the evening before and put you up overnight, serve the day, and get your travel plans to have you sent back the same night or the next following morning, whichever one works best for the member.
Tracking. I'm going to have to get back with you. I don't have access to my other calendar.
Okay. Now, having said that, where I would prefer it, if there was a difficulty, there's a bit of an uncertainty here. The governor's executive order expires September 30th. It allows us to meet via electronics. But there's also a legislative bill that we're trying to pursue, and we'll talk about that later in the materials, to kind of keep that, the advantage that we have. If we're able to keep that advantage, as an example, Mr. Irvin, if he's not able to travel to Sacramento, he could, given either the executive order is extended or new legislation is drafted, he would be able to participate electronically from where he was. If that does not happen, and he's not present physically at the meeting, he would not be able to participate unless we converted the meeting to a teleconference, and then we would have to publicly notice his location in case a member of the public wanted to participate through his location.
Okay, so to be determined.
Yeah, I think, so for today, the October 15th meeting, Mr. Irvin, are you able to tell if you can attend in person on October 15th?
I'm going to let you know. I can attempt it, but I think I have to be in Colorado on the night of the 15th. So if we can make that happen.
Okay. So on the travel side of things, we can definitely accommodate that. Even if we only had you for 6 hours and we needed to get you into Colorado a little earlier, that's better than nothing. So what I would need today, then, I think, is just a motion, a second, and a vote by members, at the very least, to have an in-person meeting on October 15th, which is a Friday, in Sacramento.
So moved.
I'll second.
We've got a motion to set a sunset meeting for the PTDC for Friday, October 15th in person, and the motion by myself, Dr. Rena Ahmed, and a second from Jesus Dominguez. And moderator, can you please facilitate public comment?
We are now open for public comment. If you would like to make a comment, please type comment in the Q&A box or raise your hand. Seeing no comments, would you like me to close the option?
Yes, please, thank you. We again have a motion and a second for a sunset meeting date on Friday, October 15th. If we get a roll call vote, please.
Alicia Benamed.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer. Daniel Drummer is absent. Katerina Ellaby.
Aye.
Jonathan Irvin. Tanya McMillian.
Aye.
6-0, motion carried.
Thank you.
One, thank you, members, for your patience in this short turnaround time. Again, we received the template on Tuesday. It is a little bit out of sync. I would have liked, at the very least, to have been able to include it in the materials. I will reach out to Dr. Drummer to make those arrangements as well. And if anything is problematic with that, I'll discuss it with the board president, and we will keep you guys posted.
Thank you very much. Glad we've got the ball rolling. If board members can take a look at the December calendar date, and if staff can make a comment regarding what we may need, or if it's just to be determined if we'll need a 1 day or 2 day meeting at this point. Are we back to being in person at that time?
We are back to be in person. We're scheduled here in Sacramento. I would leave the 2 day because at the very least we will take advantage of one of the days for a sunset session.
Okay. Great.
And my hopes are that either the 9th or the 10th is actually, the final draft and approval by the board of what that sunset template will look like to give to the legislature for January.
Okay. And those are our adopted dates, so hopefully that still works for everyone.
But just out of an abundance of caution, if we could now just have a verbal check-in with all of the members that 9th and 10th in December still works, I would greatly appreciate it.
Brooke, would you mind roll calling us?
No, of course. Okay, Alicia Van Amen?
Yes, those dates work.
Dale Armstrong?
Yes.
Jesus Dominguez?
Yes.
Daniel Drummer? We'll check in with Daniel Drummer as he is absent. Katarina Elvey?
Yes.
Jonathan Urban? Jonathan Urban?
Yes, I'll be available.
Thank you. Tanya McMillian?
Yes.
Excellent, thank you.
I think my only other comment on the 2021 calendar is that so far in March and June, we've only met on one of the 2 days, correct?
Correct.
Do we leave the adopted 2 days on there? I mean, I noticed, for September, we just have today, even though it was originally a 2 day. And then really, I don't think it makes tons of difference, but.
It would be my recommendation to leave the 2 days. During the pandemic and kind of, dealing with WebEx and technology, there are some things that have been streamlined that in person they wouldn't be. But at the same time, we've stripped down the agenda a little bit and gotten rid of some of the things that are, I wouldn't say extraneous, but are nice to have. We've lightened the presentations from staff, the presentations on certain descriptions of what services we would provide. We're going to be having a presentation today that's like that. But in person, it might take a little bit longer and would have a more substantial and robust Q&A.
Yeah.
And so that 2 days is still, I think, at least for planning purposes, we should leave them on the calendar.
Okay, but for 2021, we did only meet for 1 day in March and 1 day in June, but
Correct.
they're both there. So leave them there?
Oh,
Because it's the
for the
adopted
previous calendar,
because September, we just have today on there.
I think that's a kind of a cleaning house issue, and it's completely up to you. We'll move them. That's an adopted calendar, so we just need a motion to correct both the June and March dates to show, essentially what happened.
We did adopt this calendar at the last meeting.
We did. But if we're going to amend it, we're going to have to adopt it again. We're going to have to anyway. We just added the October meeting to it.
If it's adopted as is, and we just adopted this sunset meeting, I think we're fine.
Okay.
Yeah.
So we will reflect the March and the June single day versus 2 day in the calendar for material purposes or materials and board meetings moving forward.
Okay. Any other board discussion about 2021? Okay, hearing none. Let's move on to the proposed 2022 meeting calendar and have members take a look at the dates. And I know it's a little in advance, but I guess we'll also want to keep in mind that we'll be adding a sunset date in there. Jason, you want to talk about that a little bit? And
Sure. So while the report is due the 5th day of January, we can expect to have a sunset hearing sometime in late April. Well, at this point, you can expect it anywhere between late March and early May, given the history of what's been going on lately. So typically our hearing would be March or April. Things have been moving around quite a bit. Sunset has gone down the list a little bit of priority compared to some of the COVID kind of things. It's kind of hard to determine in 2022 what will be the case. But we will be adding as soon as we know. And I would like to think that by the December meeting, we'll have a better idea of when our hearing dates will be. And so hopefully by the December meeting, we can add it to the 22 calendar.
okay. Any board member comment on the 2022 proposed calendar? Moderator, can you please facilitate public comment on the 2021 calendar and 2022 calendar?
This is the moderator. Public comments are now open. If you would like to make a comment, please type comment into the Q&A box or raise your hand. Seeing no comments, would you like me to close the option?
Yes, please. Thank you. Okay, agenda item number 7, Executive Officers Report.
I provided the report in printed materials this time around. One of the things that I'd like to highlight but not steal the thunder from, we will touch on it in a later agenda item with applications and licensing, but we'd like to welcome Monet Dyson as a member of the applications and licensing team. She will be handling intake of applications for initial licensure, also providing a lot of support service to the rest of the staff around her. And it's a position that was vacant for quite some time, and we're happy to have it filled. And then also, the board's familiar, due to vacancy, we have a number of recruitments that are still pending. We're looking for a registration or a regulations analyst, another office technician to provide support within applications and licensing, as well as a staff service SSA analyst in that unit as well. And to kind of fill the empty void that Elsie Ibarra left in the enforcement manager's position, we're still trying to seek her replacement as well. It's proving to be quite difficult to find somebody to take Elsie's old role.
So I think at our last June meeting, I had asked about that, and the process to replace her was going to start like in July.
Mm-hmm.
So that's ongoing now.
It's ongoing now. We're still creating the actual duty statement, and we hope to be posting and actually searching for that position. The delay is we don't want to have too many packages kind of out there in recruitment at the same time. So we do have the regulations analyst that is out. We actually had to go out a second time looking for candidates. The global pandemic, COVID, those kind of things have made recruitment for new positions and employees quite difficult. The pool is smaller than it normally would be. The arrangement of an interview process electronically over Zoom or Teams or something like that has proven to be kind of difficult, and there's just not as many applicants. People are kind of scared to move around given the state of affairs.
Thank you. Can you give the board a sense of how the workload is getting completed given these vacancies? I mean, I know, like 5 years ago, I remember we were pretty well understaffed, and it seemed everyone, staff just picked up and did what they needed to do and helped out and spread themselves around. But do these vacancies cause any, undue burden on any particular unit?
Sure. There's something that I've often said about this staff is that with limited resources, whether it used to be square footage or number of bodies per caseload or something like that, they always still seem to manage to get the workload done. Your question's an interesting one from the standpoint of, are there things that are being sacrificed? And the answer is absolutely, there is. It doesn't really affect applicants or licensees all that much, but it does affect staff. I mean, they're being creative and trying to kind of get things done. COVID is just like an added layer of complexity on top of that. And so where we have telework schedules set up, there are still staff here at the office that are helping facilitate that work, which is an additional workload to them. An example of, 2 or 3 permanent staff that stay in the office Monday through Friday, answering calls and serving as receptionists, if you will, distributing those calls to those folks that are working from home, scanning documents, printing documents, putting them where they need to be, or sending them to staff that are working from home. So all of those things, while they manage to get the workload done, are just tedious and time-consuming. And, one of the cautions or the fears that I have is that leads to burnout at some point.
Yeah.
The 2 positions in applications and licensing are, while they're vacancies, they're limited term positions that we're seeking, meaning that we see on the horizon an additional workload coming, and in preparation, we're creating these positions. We don't have position authority for them, so they're not positions that were vacant. They're vacant now because we've created them as a limited term. But they're designed to help alleviate some of that workload that is coming, and that we're starting to see now, but to help the applications unit not fall behind as a result. The AEO/SSM, the manager of the enforcement unit that Elsa is serving in right now, she's bearing the brunt of both, which I thank her for. As an AEO, she's taken a lot of the load off of me. I can certainly appreciate that. But she is still essentially the enforcement manager. So until we find a candidate to replace her, but she will have to train that person anyway, there'll still be kind of a bumpy transition.
Okay. And how about the regulatory position?
The regulatory analyst is admittedly kind of looking for a unicorn.
Yes.
Trying to find an analyst that has regulations experience is difficult enough, especially with some of the things that we've experienced over the last couple of years. The regulations process itself with OAL has changed, within DCA has changed, with the creation of the reg unit has created a change, but limited term also makes that less of an attractive position to apply for.
I see.
I think my own staff and even staff from all over DCA are very familiar with the way the Physical Therapy Board uses a limited term position. We usually create that limited term position with the intent of making it a permanent position through a budget change. But not everyone knows that, and so it's less attractive. So even with the normal recruitments of some of those positions, where we haven't seen a lot of participation, we don't get a lot of applications, for that particular position, it's even worse. Mm-hmm. So the pool is even smaller. We did receive applications, went through them, realized that we needed a few more. And so just to get a couple people to interview. So we've re-advertised, we've gotten those applications, and we're reviewing them now.
Thank you.
One of the other things that I wanted to bring to the board's attention, I'm sure they've seen in the media, but on July 26th of 2021, the governor's office implemented measures that will require state workers who are not vaccinated or cannot prove their vaccination to be tested weekly. And we'll be putting that into place here at DCA starting next week. And so we're not really quite sure what that process looks like. At a bare minimum, staff will have to test before they come into the office. And so we're going to have to look at, what dates we'll be testing on and how we accommodate schedules and that kind of thing. And as long as they test negative, they'll be allowed to continue to work. In the event that they test positive, obviously they'll have to be quarantined at home. So that's been a resource draw as well, and will continue to be one until such time it's no longer necessary.
Madam President, may I ask Mr. Kaiser a quick question? So, thank you so much. Jason, just for clarification, when we come up to DCA, so how do you want us to provide proof of vaccination? Do we just bring up our card, or do we upload it somewhere, or is that even a necessity? Just looking for some guidance.
That's an excellent question. We were struggling with that this week. We thought the testing was going to go into place this week, and we had made arrangements with the one member we knew would be in attendance. As board members, you all will be affected by that as well. And so our board liaison here at the board will be reaching out to you with an email that essentially directs you to a portal where you'll be able to upload your proof of vaccination if you have it. And then for those members who don't have proof of vaccination, we would have to require you to be tested before we would actually allow you to enter the building.
Thank you, sir, for the clarification.
No problem.
Jason?
Yes, ma'am.
Quick question. So I remember reading something about when the state staff is tested, that someone has to watch them being tested. Is that true? And if it is true, how does that affect your department?
Excellent question. I'm not sure where you saw that, but it is true. We have to provide staff for the testing process at level SSM1 or higher. As in this example, either myself, Elsa, Liz, or Sarah would have to be here to help and facilitate the test for all staff that are coming into the building. Keep in mind, we have staff that are working remotely from home that are only in the office 2 to 3 days a week. Even if they come into the office off hours just to pick up documentation, drop off documentation or something like that, they would still be required to test. And so we would have to accommodate that in our schedule to make sure that one of our managers is here to make sure that happens. And we have a limited testing window with the vendor that we've been provided of 8 to 5, Monday through Friday.
Thank you, Jason.
You're welcome. So moving on, the last item that I have to report on the executive officer's report is the relocation. I think you guys are probably tired of hearing percentages of how complete the move is, and I'm just going to do it one last time. It's 99% complete. We have one or two little things that are, well, not little things, actually pretty heavy monumental things. Most importantly, we don't have our new phone system yet, so we're still kind of fighting with old technology and new technology and creating a bridge between them. So we haven't been able to kind of glean that efficiency from the phone system as we thought we would have by now, where when the phone rings for a particular staff member or group of staff members, it rings for all of them. Right now, we still have to have somebody in the office field the call, forward the call to the next staff member as appropriate. I don't have an ETA as to when we'll be receiving the equipment so that we can make that final transition to the new phone system. I'm hoping that it's very soon, because I think that's something that will definitely help us out. And COVID-19 has been a factor in that delay. suppliers don't have the equipment that they need, don't have the staffing, ship the equipment that they need, and so on and so forth. So, again, hopeful to be able to provide a 100% complete by the December meeting.
I hope so as well. Board member comments for the executive officer's report?
No specific comments for that, Madam President, but I think Ms. McMillian has her mic on. I'm getting an echo. She's unmuted, I believe.
Looks like she's not ready.
Still green. Ms. McMillian, your mic on your phone is unmuted. There we go. Nope, it's still unmuted. There we go. Feel free to unmute if you want to chime in. Again, any board member comment on executive officer's report? And moderator, can you please facilitate public comment on executive officer's report?
This is the moderator. Public comment is now open. If you would like to make a comment, please move to the question and answer box and type comment. When prompted, please click the unmute button. Seeing no public comments, would you like me to close the option?
Yes, please. Thank you. Are we ready for our presentation this morning, Mr. Kaiser?
I believe we might be. We're looking to have Emily Kendrick and Laura Sweet provide that presentation. I believe they're on the call.
Yep, we're ready to go.
Excellent.
Thank you so much. Take it away.
Good morning, Madam President, board members. Your executive staff has asked us to provide you with an overview and update of the Division of Investigation. Joining me today will be Commander Emily Kendrick, and my name is Laura Sweet. I am a retired annuitant. I retired from the Medical Board of California and was asked by the DCA executive staff to come back and work with the Division of Investigation in light of some of its current vacancies. So we're happy to be here today and welcome any questions that you have in order to understand what we do here. So if somebody would just let me know how to move this slide forward.
This is the moderator. We would like access to the slides. Which one would be? We would like to give one of you access to the slides.
Yes, you're breaking up just a little bit.
Moving the slides forward. Forward.
Just let me know if I need to do anything.
This is the moderator. Moving the slides forward. This is the moderator. I had trouble understanding.
Yes, I'm trying to.
Hello, this is the moderator. Can you hear me?
I can hear you now. You are breaking up a little bit. I'm just trying to get control of the presentation so I can move the slides forward.
Will you be the one? Is this Laura? And will you
Yes.
be the one controlling the slides?
Yes.
Okay, wonderful. We're going to assign you to the slides. Hold on just a moment, please.
Thank you.
Okay, this is the moderator. Laura, you should have control now. On the left-hand side of the screen, you should have up and down arrows to change the slides.
Perfect. Wonderful. Thank you so much. And thank you. My apologies for this. So just to get started, this is the structure of the Department of Consumer Affairs and where everybody fits in. So the boards and bureaus are underneath the Department of Consumer Affairs, and the Division of Investigation fits in between that, as we are a law enforcement agency. We were established in 1961, and our function is to provide investigative services to the boards, committees, commissions, and bureaus. And our mission is to provide law enforcement services in order to protect California consumers and licensees by effectively and efficiently enforcing laws, regulations, and professional standards.
Good morning, everyone. This is Emily Kendrick, the Northern Area Commander, and I will just go over the overview of how our division is organized. So it is headed up by our chief for the Division of Investigation, which is an appointed position by the director of the department. It's currently a vacant position, but we do have an individual in background for that. At this time, Deputy Chief for the HQIU unit is our acting chief, and that is Kathleen Nichols. So all of our staff currently report to her. So our unit is, or the Division of Investigation is made up of 4 units. We have our Enforcement Support Unit, and which is also our Case Intake Unit for IEU. And this unit is very crucial to our organizational structure because they are responsible for all of the complaints and cases that come in to the division from the various boards and bureaus. They are responsible for determining the appropriate jurisdiction for these cases. They ensure that the cases fit into our case acceptance structure. We have a structure for whether or not we will accept or reject a case, and they review these complaints that come in and determine the eligibility for acceptance. They also are complete quite a bit of preliminary upfront work for our investigators. They run background information on the subjects, witnesses, complainants to get the investigators the most up-to-date information. They are also tasked with providing all of our cases electronically. This is a new structure for us. Usually everything was printed, compiled into a case file, and then mailed to each individual field office. Now our intake and enforcement support unit is responsible for sending everything out electronically. And this is huge in our case aging because now our investigators are able to get the cases immediately versus having to wait for mail or wait for somebody to be able to physically print off and compile a file together. Another unit that we have under the Division of Investigation is our Special Operations Unit, and they handle the internal affairs, background investigations for our staff. They provide training, and they also provide our computer forensics. Sorry, the computer did something weird there. The computer forensics for our investigators. Whenever we seize electronic documents, or computers and cell phones, they can go through those items for us. They also handle workplace violence complaints. Now, our investigative units are the Investigation and Enforcement Unit, and there are 7 field offices statewide. We have Sacramento, which houses 2 teams. We have Hayward, Central Valley, which is located in Fresno, Chatsworth, Lakewood, Ontario, and San Diego. And then the Health Quality Investigations Unit has 13 field offices. And this unit was formerly known as, or was formerly part of the medical board doing investigations for them. But after July 1st of 2014, they've merged in with the Division of Investigation. And as you can see from this slide, the Investigation and Enforcement Unit conducts investigations for approximately 35 boards and bureaus, of which the Physical Therapy Board falls under that unit. So along with cases for the Physical Therapy Board, the Investigation and Enforcement Unit is also conducting investigations for these 34 other boards and bureaus. And then the Health Quality Investigations Unit, they are responsible for medical board investigations, the Physician Assistant Board, the Board of Podiatric Medicine, as well as the Osteopathic Medical Board.
Sorry, my cursor is hypersensitive. So we at DFI conduct both criminal and or administrative investigations. So based on the case acceptance criteria that we'll discuss in a moment, these are the types of things we do. A case can straddle both the criminal or the administrative arena, and there are different burdens of proof and different rules attached to criminal versus administrative investigations. So as peace officers, DFI investigators can arrest people. They can write search warrants. They do carry weapons. The burden of proof for the criminal arena is beyond a reasonable doubt, which is much higher than our administrative burden, which is clear and convincing evidence. So typical case investigation types include prescription narcotics violations, a lot of diversion. I'm sure everybody's read quite a bit about the opioid epidemic and the extremely unfortunate increased occurrences of overdose deaths. So that has been a big focus for some of our staff. We get a lot of unlicensed activity cases, which is a straightforward criminal allegation, false advertising, the illegal practice of medicine. So when somebody's operating outside of the scope of their practice, incompetence and unprofessional conduct. So with the current case acceptance criteria, these would be cases that have the potential to result in patient harm, wrongful death cases, and that can be from somebody who's so extraordinarily negligent that it contributes to the death of a patient, or, for example, overwrites prescriptions or writes prescriptions inappropriately that results in the death of a patient. So we have had manslaughter and second-degree murder charges filed for those types of cases that are exceptionally egregious. We have fraud, patient abuse, identity theft, assault, and sexual misconduct is another large component of the cases that DFI handles. So this is a slide that depicts the process of how when a case is received to the point that it is adjudicated, and it's color coded to give you an idea of what your board controls versus what DFI controls and the district attorney and or attorney general's office controls. So essentially the board will receive a complaint and your staff will determine whether or not there is jurisdiction, whether or not it is within the realm of what regulations and laws you promulgate. And then your staff will look at the case referral guidelines for investigation to determine if it's a case that can be handled within your board or if it requires referral to the Division of Investigation. So if you move to the right, where your in-house board staff can investigate and establish whether or not there's sufficient evidence to move forward. And your staff can also refer cases to the Office of the Attorney General, issue citations. So it will be reviewed by your staff going down. The case can be closed or rejected. Staff will typically, for quality of care types of cases, need to have an expert review the case. Then, depending upon that expert opinion, the matter is referred to the Office of the Attorney General, who represents your board, and they will file what is called an accusation, and that is just the legal name of the document. And then that can be resolved via a stipulated agreement or actually being heard at an administrative hearing. And then whether or not it's heard by a judge or a stipulation, a decision is arrived at, and then you as board members are the final say as to whether or not the discipline is accepted or rejected. So also if the respondent, so the licensee against whom charges have been filed, if they disagree with the board's final decision or the ALJ's, administrative law judge's final decision, the licensee does have the opportunity to appeal to a higher court. So that's how it goes through your process. Now, when it comes to the Division of Investigation, as you'll see in the blue, So if it's an appropriate case referral, the board will request service via an RFS, and it will come to the division. And as Emily mentioned, we're now trying to convert everything to be electronic to expedite, because case aging is one of the primary reasons why the executive director asked me to come back, is to really work on getting those numbers down, because the quicker we can conduct these investigations, that correlates to increased public safety. So the case will be assigned to an investigator, and an investigation can encompass a variety of things, and it's generally fact-driven by the complaint. It will generally always involve the interview of witnesses, the interview of the licensee, or if the person's not licensed, the subject, the acquisition of documents, medical records. Sometimes it will entail an inspection with one of your board experts or inspectors. It might include an undercover operation. Sometimes we have to write search warrants. Lately, we're writing a lot more investigative subpoenas because patients sometimes don't wish to cooperate, particularly in over-prescribing cases. So patients are reluctant to, if they do have an addiction challenge, they might be reluctant to share their records with us to cut off their supply. So some of these cases can be exceptionally protracted by that investigative subpoena process. The DFI investigator then will prepare an investigation report, or they can also prepare a misdemeanor citation, which would involve the criminal process. They will submit that investigation report, and they can issue a citation, and it's kind of similar to a traffic ticket, where the person has to sign for it and then promise to appear before the district or city attorney. But often the investigator will submit their investigation report to the district attorney's office, who will make a decision whether or not to file the case criminally. And that will result in either a trial or a settlement or a conviction or acquittal. If the case results in a conviction, then that information can go back to the board for them to take administrative action. So it's a complicated process. And it does involve moving parts of people in different levels of control. So what the board can control, what DFI can control, and the AG's office. So that makes our process unique.
Okay, Laura had mentioned previously about some of the responsibilities of our sworn staff. So with DFI, our investigators are all sworn police officers. And with that comes various powers. So they each have the authorization to carry firearms. They have the power to arrest. We do issue the misdemeanor citations, and we also file criminal charges with the district attorney's office if they are felony charges that we can substantiate. Some of the other responsibilities are implementing search and seizure requirements, which for that, the investigators during undercover operations, during stings, during search warrants, they may wear body wires, record surreptitiously. We also obtain and serve search warrants that must be signed by a judge. And in addition to that, all of our investigators, in order to become police officers, they must successfully complete the post peace officer academy. Some of our investigators have had the full basic academy, and then some have had the specialized investigators basic course. And then our investigators are all trained to deal with high-risk situations and violent offenders. And it's crucial because we deal oftentimes with the narcotics, those that have been diverting narcotics, taking it for themselves, that they're under the influence. We deal with a lot of subjects, a lot of licensees that fall into that category. Now, many of the boards and bureaus, they have non-sworn investigators, and then their analyst employees also have some similar powers like our sworn staff, but there are differences. They have a limited power of arrest. They can issue a citizen's arrest, but that does come with a liability. So if you're going to issue a citizen's arrest, that increases liability to a board or bureau, as well as the department and the individual themselves. They have the ability to subpoena records. They can interview witnesses and subjects. They also testify in court. They'll serve as an expert witness. they'll gather documents, and they'll write their reports as well. And DFI investigators and the physical therapy board inspectors, we work as teams when we do receive cases from the physical therapy board. So when the cases come into our enforcement support unit and then are shipped out to the various field offices, one of the things that come with those cases is what's called an RFS, a request for service. And oftentimes when the analyst with the boards know that a case is going to require an inspection, most of the time, from what I have seen, they already have established communication with an inspector and have somebody lined up to go with our investigator when the investigator is ready to. So they'll put a note in the RFS stating, hey, give us a call, and we already have an inspector lined up. I'll get you the contact information and you can coordinate schedules from there. So at that point, our investigators will reach out to the board, get the inspector's information, and they coordinate a schedule to go out to the facilities. And when that occurs, the inspector is responsible for, all of the requirements that the board has established in the Practice Act that the facility is required to maintain. Our investigators don't necessarily know all of those regulations, but the inspector will. And so the inspector will ensure that they're meeting those requirements. They will also be reviewing patient records. During this review of patient records, they maintain a list of the patients' names and contact information, which along with all of the treatments and whatnot that they see that is either aligned with what they're supposed to be doing or a violation of the Practice Act. But what's critical for the DFI investigators is getting that contact information for the patients, because we're not entitled to receive the copies of the patient records, and we're not allowed to see them until we have a release or a subpoena. So while the inspector is reviewing the records and going through those items, the DFI investigator will be conducting interviews of the employees and possibly the subject at the facility. And we do rely on the inspectors as well. If something comes up, if a subject says, gives us information that we're not sure of because it's very specific to the profession, we will rely upon that inspector who's there to give us some guidance to help further our questioning as well. So once the inspection of the facility is complete and the DFI investigators have the list of the contact information for all the patients whose records were reviewed, and that the inspector has deemed that there's been violations, our investigators will then notify the patients, ask them to provide a release so we may obtain their records for the dates in question. And then if we do not receive those releases back, at that point, then we initiate the subpoena process. That process can be lengthy, especially if a patient does object. Then that goes into a whole nother realm of now we have to go back to the board and determine if the board wants to do a subpoena enforcement process. And that's lengthy as well. So that's where we're at with the inspectors in DFI. We've had a great working relationship with all of our inspectors and our board analysts in facilitating this. And it's been very helpful to have it done for us at the forefront, because it definitely eliminates some time. And the need for all of the patient names comes into play because the AG's office, when prosecuting these cases, requires to have the names of the patients. They do not want redacted records. So that's why we have to go through that process in order to obtain the records.
So I had previously mentioned the new complaint referral guidelines, and this went into effect in January of 2016. So the only types of cases that can be referred to the Division of Investigation now are deemed the most urgent category and cases of high concern. And these criteria are set forth here, as I'd previously mentioned, sexual misconduct, drug overdose, cases where there may be potential for the licensee to behave inappropriately, aggressively. Those cases can be referred to us. So I won't bore you by reading through each one of these, but these are the new criteria. And then cases that will be retained by your staff are just general unprofessional conduct, things that really don't require any peace officer status. So there's really not going to be a potential for the need to arrest somebody, the need to write a search warrant, the need to surreptitiously record. and no heightened threat level. And so those are the cases that are retained by your staff. And they do there are very similar activities that they undertake compared to the peace officers, as Emily mentioned. But basically we're trying to maximize the cases that require the peace officer status, because peace officers have to have undergone a 6-month or a 4-month academy. So Emily mentioned the basic academy, which is about 6 months. The specialized academy is about 4 months, but it's very difficult now to get people into that academy because they're very limited in when they are offered. So the time commitments for qualifying with a weapon and the defensive tactics, these are investments that are take a little bit more money. So I think one of the intents of this complaint criteria was to just maximize who can do what in order to do it more quickly. So these are some statistics accurate as of 9/13. And just to give you an idea of how your cases have trended during the past decade. So it's interesting because it's pretty similar to where we are now. In 2010 and 11, we took 91 cases, and in the last fiscal year, we did 93. The only thing that's interesting is you'll see like a spike in 2013 where there were 120 cases, and that is, soon after that, the new case acceptance criteria went into effect, where you'll see the case intake went down, but it does seem to be trending up. And we had a little reprieve because of fewer complaints due to the pandemic, but right now we're at 21 cases for the PT board. And then cases closed are similar, just they generally correlate to the number of cases received. So far this fiscal year, we have closed 6 cases. Average age of closed cases, you'll see we need to be doing better here. We're at 219 days in 10/11. And we went down to 165, which is ideal. Our goal is to have cases that are not highly complicated completed within 180 days. And the 2021, 1920, that's not something we are aspiring to repeat. The 6 cases that have been closed, part of the reason why this number is so high now is because so few cases are being averaged in, and because the emphasis is to get rid of these older cases. So we have implemented a whole bunch of new electronic processes to expedite. The supervisors and the commanders are required to be doing case reviews with age cases much more frequently. I've been very involved in reviewing age cases as well to see what we can do to remove obstacles, and just we're giving the staff a lot of data that they weren't getting so that everybody can know where they stand, what expectations are. We've been working on training, instituting time management training. So that will be my focus once we have some of these vacancies filled. And as Mr. Kaiser mentioned, the recruitment effort during this pandemic has been severely impacted. It is very difficult to find candidates, and we are suffering from that same issue, trying to find qualified people. And then if they don't come to us with the peace officer standards and training, then we need to sponsor them through an academy, which is an immediate loss of about 6 months before somebody is up and running. So that's a definite obstacle, as well as there are competing law enforcement entities. Everybody's competing with each other for the same candidate pool. And some agencies are much more competitive in terms of salary. So these are some of the struggles that we're facing. But I applaud the DOI staff because they have been working so hard, and we have made tremendous strides in the past 6 months in reducing our case aging. So I am indebted to the folks who are accomplishing that. And then the average hours of closed cases, this is another topic of interest to me, and making certain we're being as efficient as possible and that the billing and hours are appropriate, that we are maximizing, our efforts in terms of, not taking forever to write a report. Or so the supervisors and commanders are also paying much closer attention to these figures and be able to review cases at intervals and review what's been done on it and assess if the time billed has been appropriate. So you can see we came down a little bit in 21 and 22, and I'm hoping that number is even less in the upcoming months, in this upcoming fiscal year. So that concludes our presentation, and we would welcome any questions that you have.
Board member questions or comments about the presentation? Laura, this is Alicia Dina Amen. I just want to thank you for that presentation. I thought it was fantastic. If you wouldn't mind going back to the chart where it shows the decision tree of when a complaint is received and where it might go.
Absolutely. Right here?
Yes. Thank you for this. This is so helpful. I don't know if this is included in board member orientation training, but I would love a copy of this. It really helps to make sense and picture where things have come from and where they might go. So just for me, visually, this was very helpful. Thank you for it.
Oh, you're so welcome. And I have to give credit to Stephanie Whitley because she's the one who organized this presentation. So I pilfered it.
Yeah, kudos to Stephanie for us. Thanks so much. And also, thank you for preparing specific charts for the PTDC. That's helpful as well. On the aging chart, I do see that the trend is going up, and you mentioned that there are some vacancies. So my question would be, if those vacancies were filled, do you think that, those trends would be coming down? I think it might be, let's see, a slide before, the aging.
Oh, sorry. No, it's that. Yeah, let me do it.
Yes.
Yes, absolutely. The more staff that are here, that lowers the investigator's caseload, and that always translates to a quicker turnaround on cases. And I mean, some of the things that there are some things we absolutely can control to address this. And one of the first things that I realize is that people, who don't know that our expectations are not clear about what we're trying to achieve with case aging. And so we're making that very clear, and then also giving data every month, a ton of data points to our managers, and also just trying to dive in and help when there is an obstacle. And one of the things that I recognize, and this was a similar problem we had at medical board, is medical record acquisition can completely skew these statistics, because if you're in a situation where you're having to do a subpoena enforcement action, that can add up to a year to a case. So we're trying to get staff to immediately start getting those records requested when it's appropriate, if it's not going to compromise the investigation, to really get on that and not let, like, sometimes we're thwarted by licensees who don't want to participate in the investigation, and it can become protracted because of their acquisition of legal counsel and delays and things like that, and just taking a position of lesser tolerance for those types of delays. So I think staff really do understand the importance of wrapping these cases up as soon as possible. And again, we have been impacted by the vacancies. So whenever caseloads go up, case aging goes up. So there is a distinct correlation to that cause and effect.
Thank you.
just if I might add a little context to that too, an explanation of the numbers, but also kind of in defense of D of I and even board staff is, if you look at those numbers, there's a couple things that are common with them too. The number of complaints increases, and all of those cases are divided amongst the same number of staff. Obviously, the number of case aging is going to go up, but the added complexity of a global pandemic can't be understated. I mean, or overstated. It makes it difficult in every line of communication, and where we've, and DFI both have advanced in, electronic communication, data portals that we can upload and download to and eliminate paper and all of those things, they're great. But the general communication that occurs between us and licensees and us and complainants and us, DFI, to the DAG, to local law enforcement agencies, all of that has slowed, and naturally so. So that absolutely does add to the case aging effect. Internally, just expressing frustrations from staff, even complainants that have filed a complaint with the board are much more harder to get a hold of for follow-up than they've been in the past. And part of that is because of COVID. So just to kind of put those numbers in perspective, one, the lowest common denominator is being just how many cases you can divide amongst staff. And both for DFI, PTBC shares that frustration also. But just the global pandemic in general, while we've figured out ways to speed certain things up, the general process has slowed.
I'd like to also add, thank you so much for pointing that out. Cases that require a facility visit or an inspection during the complete shutdown era had to just sit. So, I mean, because people were not working, facilities were closed. So that has significantly impacted the case age average. So you have, maybe 10 cases where absolutely nothing could be done during that time period that adversely impact that average.
And even after that authority was kind of given back to us and it became normal to do those site visits, just pairing an expert consultant with a DFI investigator and getting a date on the calendar and those kind of things, that's where the slowdown process occurs also. So, given the circumstances, I think the rise or the spike that we're seeing in the data is actually appropriate. I think we should expect to see it. I think that it's a given, if you will.
Thank you.
And just as Laura, just really quick too, as Laura mentioned earlier about our case reviews, this is a new process that we've implemented over the last year or so for our supervisors to be conducting case reviews with the investigators monthly, which hasn't been a process we've implemented in the past. It was more quarterly, or just when a board would ask, we would then go to the investigator and ask them about it. But since we have implemented this process, we have seen case closure rates for all of our boards and bureaus, for the most part, improve, because the investigators we are holding our investigators accountable, and we're helping facilitate the work. So if they get stuck and their wheels are spinning, we're not going to just allow it to just sit. We're going to have our supervisors assist them to keep these investigations moving forward.
Thank you. I'm going to pause and see if there's any other board comments.
Hi, Alicia, it's Katerina.
Hi there.
Just wanted to thank both of the presenters. This presentation has been super informative. One of the trends I'm seeing on this slide here with our average cases, it appears as though since we were able to expand our outreach program, the number of cases has significantly decreased. So I don't know if that's a direct correlation, but just an observation I wanted to make.
I appreciate the observation. I don't know how much credit we can take for it, but you guys know me. I'll take some if I can get it. So it is something that, we stress to applicants that are coming into the profession about substantial relationship and those kind of things. So, yeah, hopefully that's true. Hopefully that bears out.
Thank you, Katerina. Other comments from board members?
Madam President, this is Jesus. I just had a quick question. I think part of it was already addressed in the discussion, but just want to make sure it's clear for me. Both on the respondent side and the complainant side, there willingness to participate in the process, as it were. How long, what's the prudent length of time to wait for responses from either the respondent or the complainant? And I'm just wondering how much time that adds to the average age of the case.
We don't track that data. Medical board did track that at one point, but it, again, with everything being as crazy as it has been, we have not implemented any type of tracking with regard to that at D of I. But it's case specific. There are some cases, if we don't need the complainant's participation and we can continue the investigation and it seems appropriate, we will continue with it. But if we don't receive cooperation, and we'll give a deadline, usually it's about a month, and just saying, you know, we've tried to contact you on this date, this date, this date, and we can't proceed with your complaint any further without your cooperation. So it depends on the allegation. It depends. There are just a variety of factors. So it's hard to say how hard we will continue to try to get a hold of a complainant or try to you know, establish whether there's merit to a complaint outside of the complaining party. Same thing with the subject. Sometimes, you know, the respondent or what we call them subjects until an accusation is filed of the subject of a complaint. It just depends on the allegation. Sometimes we just need to show that we made the effort to let them tell their side of the story. And if they don't choose to participate, we just move forward without their information. And then sometimes you know, depending on how closely a case requires working with a deputy attorney general, they will, you know, really want the participation of the subject. So again, it's very fact driven on the complaint. And there is subpoena authority to subpoena a subject of an investigation, but we also have to be careful because you can't compel. So if you have a case that straddles criminal and administrative, you can't issue a subpoena and then ask somebody to incriminate themselves. So that's another factor too. If there's a criminal component to it, we can't compel the subject to participate. So sorry, I know that really doesn't answer your question in terms of what's our tolerance level in terms of time, because it does depend on the case.
I really appreciate that. Those of us in academia embrace the term, it depends. So I appreciate it.
And just to echo Ms. Sweet's comments, is, you know, it is very case by case specific, but it's kind of like a golden rule would just be due diligence. The board staff and DFI staff did their due diligence in trying to reach a particular respondent or a complainant in the matter. We usually like to use the rule of three. You know, we send them 3 notices, and then, you know, depending on the egregiousness of the charge, we may do a 4th or a 5th even, or we may choose to move forward with the veracity of the evidence. It may not be necessary to have the respondent involved or the complainant involved for that matter. So on a case-by-case determination is how we would move forward.
Thank you. Any other board member comments? Questions? Okay, I think I just have one more question, and that's regarding your mission statement. Here, as board members, our mandate is consumer protection, and I saw in your in your mission statement that your mission includes both consumers and licensees. So as a board member, it just sounds foreign to my ears, but I'm sure there's a reason for that. Can you give us an example of how you provide services to the licensees?
Absolutely. So as objective finders of fact, as peace officers, we are objective finders of fact. So by this, we mean exonerating licensees falsely accused of misconduct. So, and our case aging attaches to that as well. So we want to protect consumers from a licensee who is a danger but also we want to protect, licensees whose reputation may be being besmirched by a false allegation. So that just, that mission statement goes to the fact that we are here as objective finders of fact. So we're not on either side. We just want to find out the truth and in that context, protect both consumers and licensees.
That's a great explanation. Thank you so much for that. And again, another opportunity for our other board member comments. And moderator, can you please facilitate public comment?
This is the moderator. We're going to switch who has control of the program. There we go. And comments are now open. If you would like to make a comment, please type comment in the Q&A box, and we will address you as soon as possible. When prompted, click the Unmute Me button. Seeing no comments, would you like me to close the option?
Yes, please. Thank you. Emily, Laura, thank you very much for this wonderful presentation and this information. If there's any way that maybe staff can help me get a copy of that decision tree.
Absolutely.
That's how much I like it. I don't know, maybe the other board members would like a copy emailed to them as well. Yeah. Thank you both, Emily and Laura.
You're so welcome. It was our pleasure.
Yes, thank you very much for having us.
Yes, you're welcome. I think it's a good time to take a short break. Yes?
10 minutes?
10 minutes would be great. Can we please come back and be ready at 10:55?
All right, it looks like we're back on track and we're going to resume momentarily.
Okay, welcome back everyone and thank you for your presence. The time is 11:09 and can we have roll call to make sure our members are all back, please?
Alicia Benaimez
Here.
Katarina Ellaby.
Here.
Dale Armstrong.
Here.
Jesus Dominguez.
Present.
Daniel Drummer. Daniel Drummer is absent. Jonathan Irvin. Jonathan Irvin.
Here.
Thank you. Tanya
Sorry.
McMillian.
My phone's.
Tanya's here.
Thank you. All members are present with the exception of Dr. Drummer, and the board has a quorum.
Thank you. Jonathan, we'll always wait for you to chime in, no worries. Again, thank you for your patience, everyone. Behind the scenes here, we're just trying to ensure that we get people who are presenting the time slots that they can have available. So with that, we're going to go through the agenda and pick up with agenda item 9, but we will have agenda item 12, the rulemaking report, at 1:30. We anticipate breaking for lunch from 12:30 to 1:30 to allow for some time frames to be met for certain people who are going to be presenting and be present for the meeting. So if we move along in the agenda, we'll pick up with the report, agenda items 13 and on before our 12:30 break. But let's go ahead and go into agenda item number 9 regarding waivers.
Thank you, Madam President. For the latest report on the waivers issued by the Director of the Department of Consumer Affairs, as the members are aware, we've had a number of extensions since the implementation of these waivers. I think no one really anticipated a global pandemic, lasting as long as it did. But there are still two waivers that are notable for physical therapy that I wanted to kind of bring to the attention and talk about a little bit of clarity. So the first one is the waiver that affects the continuing education requirement for physical therapists and physical therapist assistants. As you can see, this is the 8th extension, and the extension languages 1st through 7th, in addition to 8th. Sometimes they're kind of hard to read, so I think I want to read out a very kind of simple statement for the benefit of those that are watching at home, and just for members in general, and just even for my own staff. So with the most recent waiver issued, the 8th extension, which is DCA-21-175, what it essentially boils down to is that if your license expires or expired already between March 31st of 2020 and September 30th of 2021, your continuing competency proof will now be due by January 31st of 2022. Essentially, if your license expired during any time during the pandemic, the spirit of the waiver was to give you 6 more months. After 6 months, I think we realized we were going to need more time. And so then on and so forth with the 3rd, 4th, 5th, 6th, and now all the way to the 8th extension. So again, if your license expired between March 31st of 2020 through September 30th of 2021, your CC is now due by January 31st of 2022. And I hope that, and I say that as an inclusive statement, right? So if you expired in March of 2020, you now still have until January of 2022 to accumulate those 30 hours of CC for that particular renewal period. For the renewal period following that, you'll still be required to take those 30 hours as well. So before I move on to any of the other waivers, are any questions from the board or members?
When did the 8th extension go into effect?
July.
How does that, I guess we'll get to it when we get to the continuing competency report, like how that affects their work.
We can touch on it just briefly. As we've discussed in previous meetings, because of the waivers, it makes it very difficult to provide any kind of auditing services. And so we haven't sent out audit notices because it would be very difficult to expect a licensee to be able to provide that proof when these waivers are in place, and the deadline to provide the proof still hasn't even come yet. In conjunction with that, we also have had a kind of a higher demand in the rest of the applications and licensing unit when it comes to just processing applications received and license maintenance and those kind of things. So we've diverted resources from continuing competency over to the applications unit, they've been extremely helpful in doing that. I don't have, or can I provide kind of an ETA of when they will return to services? And I think that's pretty normal or easy to understand, because CC is, well, we've only had the 8th extension. I'd like to plan to start doing audits in February or March of next year, but even that is unlikely with the understanding of the waivers and the possibility of a 9th extension. Mm-hmm. So I can't give you an ETA of when they're going to return to that. We did touch on that at the last meeting, and we had thought that we'd be able to return to audit services by now. But with the issuance of that last waiver, I think things are still up in the air a little bit. Having said that, while they're also providing assistance to the applications unit, it's not that continuing competency work itself has stopped. There's still organizational and logistical things happening in the background, because we do want to, start to audit recognized approval agencies and actual content, and we're still building that model as well. That work continues. But for licensees and the audits for their actual proof of continuing competency, it's hard to say when we're going to return back to audits.
Thank you.
Any other questions? Okay, the next waiver that still affects physical therapy is the examination requirement for continued physical therapy treatment. And this is as a result of AB 1000, or what we call temporary direct access, where the law states that you can see a physical therapist without an involvement of a physician or a diagnosis for 12 visits or 45 days, whichever comes first. But after you get to that point, to continue treatment, the patient would have to do an in-person examination with their physician and have the physician sign off on the plan of care for the physical therapist to continue providing services. And the statute was specifically written that it had to be an in-person meeting or examination. And through the waiver, the director's waiver, we waived the in-person portion of that with the idea of telemedicine, global pandemic, providing access, those kind of things. And so that extension has, or that waiver has been extended a few times as well. And again, we're on the 8th waiver at this point. That waiver currently expires October 31st of this year. But we are in constant talks with the Department of Consumer Affairs and the director, and it may be one of those where we might extend it further given the opportunity by the director. So again, we'll have those conversations. And then just as a side note, that waiver and thinking about telemedicine may be something that the board might want to consider in sunset, having the sunset process actually amend that language and making that waiver a permanent circumstance, especially with the idea of telehealth and all of Division 2 and the ability for practitioners to utilize telehealth. I think this is one of those times where we haven't seen any kind of negative ramifications for that. So any questions on that particular waiver? Or any questions on any of the other waivers?
Good information. Thank you, Jason. Moderator, can you please facilitate public comment on agenda item 9?
We are now taking public comments. If you would like to make a comment, please type in the question and answer box, comment, and we will unmute you when available. Seeing no comments, would you like me to close the option?
Yes, please. Thank you. Okay, thank you for that, Jason. Agenda item number 10, FSBPT. I think I'd like to just see if Dr. Jesus Dominguez wants to report anything out from Education Committee or anything important that he might have on his plate from FSBPT, and then invite Jonathan in case he's had any new information from FSBPT. Not that he would, but just invite him if he does, and then maybe have Jason chime in at the end. So, Jesus Dominguez?
Yeah, just a quick update, Madam President. Let me pull up the document here. I apologize. So obviously we've still been doing everything virtually. The Delegate Assembly is scheduled to run on October 23rd, also virtual. But as far as next year's meetings, and in particular the annual meeting and Delegate Assembly, fingers crossed, it should be occurring October 27th to 29th in Orange County, California. So we'll host the annual meeting and Delegate Assembly next year in the OC. And it's anticipated that the board member and administrator training, which is scheduled for May 20 to 22 next year, as well as the Life Leadership Issues Forum. Both of these scheduled in Alexandria, Virginia for in-person. So fingers crossed, looks like it will be a go.
Yay, thank you.
My pleasure.
Mr. Urban, anything to add?
No, I don't have any updates. I do need to get in the training hopper, the orientation, but I don't have any updates.
Thank you. Mr. Kaiser.
Yes. So a couple things, just to kind of echo Dr. Dominguez. We are preparing for the Delegate Assembly coming up in October. For us, it's the 21st through the 23rd. Both Mr. Urban and Ms. Armstrong will be joining us for that. We just recently had a regulatory training in August. I believe Ms. Armstrong was able to attend some of that. But what I really wanted to emphasize, one, I wanted to thank Dale for kind of cluing in and taking as much of that as she possibly could. It was a 3-day course, half day each day, but a lot to take in, but also very beneficial. And I think, moving forward, I know that the May training is an in-person training, but I am going to be lobbying FSBPT to try and get at least access or an approval from FSBPT to have all of our board members, should they be able to attend. And I know that May, they're planning on that one being an in-person meeting. But again, I think it's extremely beneficial, as I've kind of told members in the past when I've gone to these trainings, and I'm working with representatives of other states. Oftentimes we're a little outnumbered. So there may be 1 or 2 of us there, but depending on where the training is located, we've seen full boards from other states showing up to be provided that regulatory training. And again, I think it's one of the best trainings that you can possibly get in your service or role as a board member. We've also had discussions with FSBPT that while they're providing that training in person annually, that off schedule to that, they're going to continue to provide a virtual portion of that annually as well. And so this August, I would imagine the next virtual will probably be provided next August, so on and so forth. So in anticipation of the Leadership Issues Forum for 2022, because we are hosting the Delegate Assembly in October of 2022, the better prepared we are, the better we can perform when we actually get there. So this will be the second time that I've been involved in hosting the Delegate Assembly, and it is quite an experience, and I would love to have all 7 of my members at my back when we show up for both the Leadership Issues Forum and the Delegate Assembly, assuming that all of that's allowed by the global pandemic, and knock on wood.
Yeah. One of the things that I had really wished was that when I took that training in Virginia, I wished I had another board member or our council or Jason next to us, and especially Jason. I mean, as you're going through the training and learning about things and hearing about things, I wish I had him there to turn to and say, do we do that? Can we do that? Is that something we can think about doing? And so I just wonder, Jesus, if I'm not sure that training is something that the Education Committee can chime in on, but I'm wondering if they can have or actually encourage the administrator from each state to go with their board member and even have a breakout session regularly of about 10 minutes for board members to talk to their administrator right then and there about whatever it was that was just presented. I don't know, it still resonates with me to this day, even though I took the training way back when. It is excellent training. And I took a lot of notes, but I'm sure I didn't get to follow up with Jason on every single one of those points, and it would be nice to do that in real time. So I'm wondering Dale would be willing to unmute and kind of share what she thought about the training when she took it.
Hi, everyone. The training was excellent. And as Jason mentioned, because of my work schedule, I wasn't able to attend the time over the full 3 days. So I missed Monday and I was there partial on Saturday and Sunday. But it was really good to know and to learn our relationship to the Federation and to clarify that, and also to hear from other board members around the nation. So I think those are the two highlights for me. And the format was very engaging, good. It was really nice to be able to participate.
You both reminded me of something, and I'd be remiss if I didn't bring it up. So, you know, I've expressed kind of my want and my intent in having all the members, but that also includes the board's counsel. And as of late, we've also been involving board staff more. So the managers have participated in some of the FSBPT trainings with me, and even solo on their own when we can't be in two places at one time. And it's something that, you know, I guess I've seen over the years from other jurisdictions or states, you know, based on that state structure, their administrator might also be the administrator for multiple other professions. And so maybe it's not the administrator who comes, maybe it's their chief of licensing or something like that. And FSBPT has seemed very open and willing to accommodate those situations. So in the virtual world, it's been very easy for me to include the managers in that. Again, having this whole idea of hosting the Delegate Assembly next year for California, it's even more important for me to involve the Assistant Executive Officer and the managers of the Enforcement Unit and the Applications and Licensing Unit. I think it would be beneficial not just for them, but for the FSBPT as well. And also, you know, when we are outnumbered by other states, I mean, when I say we're outnumbered by other states, I mean we're outnumbered by other states like Rhode Island. You know, and so if we're going to, if we're the largest state in the union, we have the largest licensing population for PTs and PTAs. You know, I'd like to walk in 4 deep, as they say, you know, with enough backup and enough representation. The other part that's important to me is throughout that delegate assembly, FSBPT provides a lot of training in breakout sessions. And you really need to divide and conquer to do that. And in the past, while there's been 3 of us, there's only been an opportunity for one of us to be in each of the 3 cycles. And if I can double that up, then you have that opportunity to discuss and kind of, you know, provide clarity. It turns out you ask better questions, you get to retain the information a little bit better, and it really just also gives you the opportunity as board members to network with other members throughout the nation. So I'd really like to ramp up our participation in FSBPT, and as long as the Federation is willing to allow for it and, you know, provide more access for California, I think we should take advantage of it.
Absolutely. Jesus, I think I heard you mention specific dates for 2022, and if so, can you please send those over to, would it be Brooke, to add to our president's calendar? Mm-hmm. Yeah, if you could send those over to Brooke and Jason, and we'll get those on the 2022 calendar so that board members can kind of, you know, reserve those dates, you know, for the delegate assembly and also for the training in May would be great.
Happy to do so, Madam President. I'll get those over. And to our EO's comment, Rhode Island is a state, sir? I had no idea. Thank you very much. We will represent, hopefully strongly next year in Orange County.
Awesome. Thank you for your service. Jesus.
My pleasure.
Other board member comments, other board member questions, please chime in. Okay. We are going to move to agenda item 10B, and that is DCA.
Yes, I believe we have Brianna Miller. If you could promote her to a panelist.
Good morning. Everyone hear me just fine?
Yes.
Wonderful. Then I'll get started. It's still morning, so I'll say good morning, Board President and Board members. I'm Brianna Miller, Department of Consumer Affairs' Board and Bureau Relations. Thank you for allowing me the opportunity to provide a department update today. I'd like to start out by discussing remote meetings, and I want to caveat, I apologize that some of the information I have for you today is repetitive to what has been discussed this morning, but I still hope it's helpful to you. So, DCA is receiving many questions about when and how boards will meet again in person and whether they can also continue to meet remotely. As the law and executive orders stand today, after September 30th, all boards and committees will be required to return to in-person meetings with publicly noticed meeting locations. However, due to ongoing changes in the COVID-19 pandemic, there is legislation that was mentioned earlier pending that would extend the ability to meet remotely until at least January 31st. We do not have any concrete news today, but DCA will do all it can to assist boards and bureaus to plan safely for in-person meetings, and we'll keep you informed of any changes to meeting requirements as soon as we're aware of them. Moving on to COVID-19 safety measures. To combat the spread of COVID-19 and protect vulnerable communities, California is implementing enhanced safety measures for state employees and workers in healthcare settings. State employees must show proof of vaccination or will be subject to regular COVID-19 testing and will be required to wear appropriate PPE. Board and committee members are considered employees and must follow health and safety protocols if they plan to visit a DCA location or attend an in-person meeting. Members must verify vaccination or follow face covering and testing protocols in accordance with that location's requirements. DCA's testing program is expected to roll out later this month, and you will receive details and instructions when available. And as it pertains to healthcare settings, to further protect Californians and healthcare workers, the California Department of Public Health recently issued 2 public health orders. The first requires workers in healthcare settings to be fully vaccinated or receive their second dose by September 30th. The second public health order directs hospitals, skilled nursing facilities, and intermediate care facilities to verify that visitors are fully vaccinated or have tested negative for COVID-19 in the prior 72 hours before indoor visits. We want to remind licensees to thoroughly read the CDPH public health orders and regularly check their local public health department's website for additional vaccination requirements. Questions from licensees about the healthcare worker requirements can be directed to the California Department of Public Health. And we know things are moving quickly, and there's a lot of information, both official and unofficial. And statewide guidance for the use of face coverings for the California Department of Public Health remains in place unless a local health jurisdiction issues a stricter health ordinance tailored for the situation in their communities. Many counties have revised health orders requiring face masks to be worn by both vaccinated and unvaccinated individuals while indoors. And I encourage all members and the public to visit DCA's COVID-19 website for updates and resources on the state's reopening plan, public health guidance, vaccinator resources, vaccine distribution, and more. And finally, I'd like to provide a reminder about required board member trainings and the DCA's learning management system. As a reminder, 2021 is a mandatory sexual harassment prevention training year. This means that all employees and board members are required to complete the training this year. Please be advised that you will now access this training through the Learning Management System, or LMS for short, which is DCA's training portal. We have created profiles for each of you in the LMS and informed your executive officer of the steps you will need to take to log in and access the training. Board and Bureau Relations is happy to assist you with any questions or concerns you may have about using the LMS. And ultimately, the LMS will be used to house your training records and may also be used to sign up for other mandatory trainings. And to that, I'm pleased to announce that board members can now register for the board member orientation training via the LMS. As a reminder, newly appointed and reappointed board members are required to attend the board member orientation, or BMOT for short, within a year of appointment and reappointment. The final training of 2021 will be held via WebEx on October 13th. And if anyone wishes to join, even as a refresher, we're happy to assist that registration. And as always, Board and Bureau Relations is here to help. And if there's anything we can do to assist you and your board, please don't hesitate to reach out to us. And that concludes my presentation. So I will hand it back over to Board President Robina Amen. Thank you very much for your time.
Thank you, Brianna. Do we have any board member questions or comments for Brianna? Any staff comments or questions?
No, I would just like to welcome Brianna back. As part of Board and Bureau Relations, we get a lot of opportunity to talk to her. We had a pleasant conversation last week going over the agenda materials, and it went really well. Thanks, Brianna.
Thank you. Happy to be back.
Thank you, Brianna. And so we'll move to agenda item 10C, and that is CPTA.
So it looks like there's a representative from CPTA in the queue. Her name is Tamika Island. If you can promote her. She has her hand raised now.
Tamika has been promoted.
Good morning. Can everyone hear me?
We can.
Good morning.
Wonderful. Good morning. Thank you for the opportunity to speak on behalf of the California Physical Therapy Association. I am Tamika Island, the Executive of Professional Affairs for the association. I only have a few brief updates for you all. The first is a reminder that CPTA will be hosting its final, hopefully, crossing our fingers, final virtual annual conference this year. The dates are October 9th through the 10th. The early bird registration will end Monday, September 20th, so this coming Monday, after which prices will increase by $50. So we hope to see you all virtually joining us next month. And next year, our annual conference is projected to be held in Anaheim, California, and those dates are September 24th through the 25th. CPTA as well as APTA are celebrating APTA's 100 years of service. Please make sure to watch the Rose Parade on January 1st, 2022, and look out for our CPTA float. And the final update, or I should say comment, is we'd like to extend a sincere thank you to the board and the executive officer and staff for its open door policy in regards to all communications with the association. We have appreciated the ability to reach out with questions related to the public health emergency, public health orders, as well as waivers, which Jason, you did a wonderful job of covering those earlier in the agenda. And the exchange of information with the board to provide valuable information to licensees and students. This has been especially helpful over the past couple of years, and it is much appreciated. So thank you to all.
Thank you, Tamika, and likewise, the board appreciates the open communication that we have with the association. So we feel the same, and thank you for those comments. Jason, anything to add?
Just to echo that as well. I think Tamika and Stacy and I have a very good rapport and communicate, quite efficiently. We all understand our roles. We all understand the conflict that those roles might create. We remain friends, and everything is cordial, and we get a lot done. So we recently did an outreach with CPTA for laws and ethics, specifically for continuing competency. I don't want to take it from April Beauchamp's outreach report, but as a result of that, I think we'll be doing a little bit more of that in 2022, providing a little bit more outreach to the licensing population as opposed to just the applications and schools. It'll give us an opportunity to reach their membership a little bit more directly, and we thank them for the opportunity.
Thank you.
Yeah, any board member question or comment for Tamika?
Well, thank you for the opportunity.
Thank you as well for being here. We're going to ask the moderator to open and facilitate public comment for any of the agenda item 10A, B, C for the Federation, DCA, or CCCA. So moderator, can you please facilitate comment?
Public comments are now available. If you have a comment, please type comment into the Q&A box and we will get to you as soon as possible. When prompted, please unmute yourself. Seeing no comments, would you like me to close the option?
Yes, please. Thank you very much. Okay, we are on to agenda item number 11, which is the legislation report.
The 2021 legislative session has adjourned with 694 measures awaiting the governor's signature. September 10th was the last day for each house to pass bills, and the governor has until October 10th to sign or veto those bills. There was quite a bit of movement over the last few weeks with the bills. I'll go ahead and go through each one and provide an update to the board, including amendments that occurred on each bill. AB 105, the Upward Mobility Act of 2021, Boards and Commissions, Civil Service Examinations Classifications, was recently amended in the Senate on August 31st. These amendments expanded the bill's targeted group to include disabled populations and veterans of the armed forces. The Assembly did concur with the Senate's amendments on September 8th with 58 ayes and 12 noes, and on the 9th it went to engrossing and enrolling. AB 107, Licensure of Veterans and Military Spouses, was recently amended on September 2nd. The most recent amendments included requiring a board to revoke a temporary license if the board finds that a temporary license holder engaged in professional conduct. Also, they clarified the time frame for the issuance of temporary license for the Board of Professional Engineers, Land Surveyors, and Geologists, and then they additionally added some additional co-authors. PTBC does have an exemption to this bill since we already have a process in place for an expedited license according to the provisions of the bill. The Senate did concur on the amendments on September 9th with 77 ayes and 0 noes, and it did as well go to engrossing and enrolling. The next bill is AB 225, and that's the DCA Board's Veterans Military Spouses Licenses Bill. And that bill did fail the deadline on July 14th and became a 2-year bill, which could be acted upon in January of 2022. AB 305, Veteran Services Notice, on September 1st was ordered to an active bill at the request of Senator Eggman. So a bill is essentially dead for this session. The next bill is AB 339, State and Local Government Open and Public Meetings, and this bill was amended on September 3rd. The most recent amendments removed a cross-reference to the United States Code and instead required local agencies to conduct meetings consistent with any applicable language, access, and other non-discrimination obligations. The amendment before that, on August 25th, addressed chaptering issues. The Senate amendments were both concurred on September 9th with 25 ayes and 8 noes, and it also went to engrossing and enrolling. AB 657, State Civil Service System Contracts, failed the July 14th deadline and became a 2-year bill. It also could be acted upon January of 2022.
Can I ask a question?
Mm-hmm.
Would that affect us at all?
The personal services contract?
Correct.
It does in the way that we go about hiring our expert consultants.
Expert consultants. Okay, so, all right, so we'll wait and see what happens next year.
You know, the question is, would it affect us? It would. Is it something that would have a detrimental effect or a negative effect? It's hard to say with the way that the language is being written at the time. And while I say it's primarily for expert consultants, it's essentially any contract the board enters into, right? So it could also be reports that we require for like a 820 compel, where we actually hire a physician or a surgeon or a psychologist, psychiatrist to provide a report on one of our licensees. That would also fall under that. So it's mostly enforcement related, but it's any contract work that we would utilize outside of the normal employment relationships.
And so you're for an extended amount of time?
Correct.
Okay, thank you.
So AB 1273, Interagency Advisory Committee on Apprenticeship. This bill was amended on September 1st. These amendments clarified that the bill does not require DCA or the State Department of Public Health to establish a mandate that an accrediting entity must provide earn and learn programs. They also address chaptering issues and specify that this bill's provisions become operative on January 1st, 2024. On September 10th, the Senate's amendments were concurred in with 72 ayes and 0 noes, and it went to engrossing and enrolling.
Brooke, just a quick correction on AB 339. Christina is spelled CR, not CHR.
Oh, thank you, Tanya. I'll make that change in the meeting materials. Okay, and SB 250, healthcare coverage, failed the deadline July 14th and also became a 2-year bill, so it may be acted upon January 2022. The next bill is AB 607, Professions and Vocations, and this is the Senate B&P Omnibus Bill. And this bill was recently amended, and those amendments extended the sunset dates by 1 year for 8 boards, bureaus, and councils. It also deleted the requirement for certain post-secondary education students attending BPPE-approved schools to take an ability to benefit test, to take an ability to benefit test prior to enrollment, and added chaptering language to address conflicts with another bill, which is AB 471. So these amendments, again, were concurred in with 35 ayes and 0 noes, and it also went to engrossing and enrolling. SB 731, criminal records release, was read a 3rd time on September 2nd. However, on September 10th, it was refused passage and did not make it out of the assembly. So that bill is dead for the session. AB 361, open meetings, state and local agencies, teleconferences, was recently amended. And this bill would allow the board and local agencies to use teleconferencing without complying with certain provisions in the Badgley-Keene Open Meetings Act until January 31st, 2022. This includes the requirement that each teleconference location be accessible to the public and that members of the public be able to address the legislative body at each teleconference location. There were some additional amendments that were done in the bill recently regarding the Brown Act, and an amendment to add an urgency clause, and then it also addressed a few chaptering issues that coincided with AB 339. But I just wanted to point out that many of the executive orders that Governor Newsom issued to grant boards flexibility to meet remotely during the pandemic will be expiring soon, meaning that these flexibilities will not apply to future emergencies and other events when meeting in person could be dangerous. So this bill would guarantee that local and state bodies would be able to temporarily hold meetings remotely and require the opportunity for the public to join via telephone or video conferencing to ensure that all members of the public can participate safely. So staff are recommending a support position on AB 361. And that concludes the legislative summary. Are there any additional questions that we can answer?
Board member questions, comments, discussion on this last bill that was discussed, AB 361?
Maybe a staff comment. As to the importance of AB 361, as we kind of talked about when we were looking at the remainder of the 2021 calendar and our ability to meet in sunset, and having to try and get people back to in-person meetings. I think the intent is to return to in-person meetings. I think utilizing technology and leveraging WebEx and those kind of things, it's something that we should do and exercise discretion in doing it. In fact, the author speaks to it in the bill that, and I think that's also a reason that this bill has an expiration of January 31st of 2022, meaning that once this pandemic comes to what we would call maybe an end, that it is the intent and the will of the legislature that we get back out into the community and meet with these stakeholders in person, which would also be my intent. I think there's a happy medium in between. I think we travel and we still utilize, you double the exposure. This board has a mandate to travel to Southern California and Northern California once per year, and I would recommend we still do that. I just think it would also be nice that while we're in Southern California, that folks from Northern California could also participate via a WebEx-style platform. With the facilitation from Solid in the Department of Consumer Affairs and David and Tricia with us today, it makes for a very kind of smooth, back and forth between stakeholders and the board. And having that, I think it's a win-win situation to be able to do both. I also think that the author believes that, or is at least trying to affirm that he doesn't want a one or the other situation. So staff is recommending a support, and it may be helpful, but it might be kind of much ado about nothing. We're talking about a short period of time. The bill might go into effect, and like I said, only last until, for 6 months and be gone. So this is an ongoing problem that we're going to have to, lobby at the legislature and see if we can get a little bit more buy-in. But Begley-King may be considered kind of an antiquated statute at this point, given the circumstances like things like COVID-19 and that kind of thing, and having the ability to WebEx and still responsibly provide access to the public at public meetings in physical locations like we do and like we always have at school programs and addressing stakeholders, members of the association, and consumer members of the public.
Can you help me understand why the January 31st, 2022 date was inserted?
I can't. I'm only speculating, but I think the January 31st is an expiration with the idea that there's maybe some larger change coming. So this is just kind of an extension of the governor's executive order in the absence of maybe an extension. There is still a possibility that the governor's office could extend the September 30th expiration. But, looking in a crystal ball and trying to anticipate why January 31st of 2022, the only thing that kind of comes to my mind is that the legislature is in a way expressing their intent that they don't want us to overutilize the WebEx portion and neglect our in-person mandates and responsibilities, that we would use this as a cost-saving measure and you wouldn't see boards and bureaus out in public, in person, and accessible in that fashion.
So this gives us a little bit of flexibility, at least until January, pending nothing else happens.
Right.
Otherwise, we meet in person.
We meet in person, or in those instances where we can't, we're hindered by that kind of antiquated teleconference, Begley-King requirement where every member that's in the meeting would have to provide its public location and it be accessible. And if it wasn't, couldn't participate that way. I would argue that an in-person meeting in a single location is actually more accessible through this kind of WebEx exemption that we've gotten from the governor's office. While I would argue that, I think it's a pretty easy argument to make because our statistics bear that out. We've actually had more public participation that we see through the WebEx attendance than we've ever had real people sitting in seats. And it makes it easier for them as a consumer or as a stakeholder to not have to travel to remote locations, to not have to, when we say that we have an obligation to meet in Southern California, me being a native Northern Californian, it's pretty easy for, somebody told me I needed to even just drive to San Francisco to attend a meeting. When you're from SoCal, the density factor kind of kicks in, and to drive 200 miles across Southern California to go to a board meeting is a lot different than driving 200 miles in Northern California to go to a board meeting. So again, I appreciate the situation. And like I said, I think this board has always been responsible in meeting that mandate and not just including its consumer stakeholders, but utilizing each and every board meeting as an opportunity to educate and to provide outreach to educational programs for future applicants and that kind of thing, and save the board costs. We've also been very frugal with the way we spend our money. So it's not quite perfect, AB 361, but at this point, it's the only thing that we have.
Board member comments, questions? As a board member, I really like and welcome the opportunity for stakeholder involvement as much as possible. I mean, if we traveled to a location in Southern California, for instance, maybe we went to a PT or PTA program home, and they hosted us there at their campus, we would get those local folks who would come, maybe students and staff and other public members, but then if we had this option as well, we'd have both. So, I mean, I see it as a win-win. Any board member feel impelled to make a motion?
Madam President, this is Jesus. I completely agree. I know we're potentially talking about a short time frame here, 6 months or so, but I think in the spirit of trying to be inclusive, it's kind of a win-win, right? Physical presence is always appreciated, but just to have that sort of supportive, technology to allow for more participation. And I'm also wondering, should we be thinking about staff sort of drafting a letter of support or a position of support, or is that premature?
There's just one more aspect of this that I want to add just for members' information is that the other benefit that I think that this bill provides to us in flexibility is, especially for PT board, where we really try to capitalize on the idea of having our in-person meetings on a campus of some kind that has either a DPT program or a PTA program. But each county and city and municipality in the state has different ordinance requirements based on COVID. And so where I might be able to find a location in Southern California to host us, and I might have them in mind, I might, through just arrangements, find out that they can't host us, that they physically can't do it. And we have had that difficulty over the last 6 months in kind of planning for in-person meetings for the future, where some schools aren't even allowing their students on campus still. They're not going to allow us on the campus either. And having said that, AB 361 even becomes a little bit more important to us because we may still have to exercise that telephonic way of meeting. We can always come to Sacramento and do it here in our own hearing room and still fulfill that mandate. But that that Southern California requirement has proven to be a little bit more difficult when it comes to making travel arrangements and finding some, a host for the board meeting itself, if you will. As an alternative, we can, entertain the idea of doing what some of the other boards kind of do on a regular basis, and that's just finding a local convention center or a hotel who has convention center style space and really pay those exorbitant costs to get the same effect. I don't recommend that, obviously. I don't think it's a responsible use of the board's fund, but absent the ability to use 360 Will, we may not have any other choice to still fulfill the mandate of the travel of 2 locations, Northern California and Southern California.
So there is a recommended support position on agenda book page 50. If a board member wants to make a motion.
Yeah, Madam President, Jesus, I move to, gosh, help me out with the language here, direct staff to draft a letter in support.
Yep.
I second it. It's Tanya.
Thank you. We have a motion by Jesus Dominguez and a second by Tanya McMillian. Any further board discussion? And moderator, can you please facilitate public comment?
Public comment is now available. If you have a comment, please type comment in the Q&A box and unmute your mic when prompted. Seeing no comments, would you like me to close the option?
Yes, please. Thank you. And so, motion again by Jesus Dominguez and a second by Tanya McMillian. If we can have a roll call vote, please.
Licensure Van Amen.
Aye.
Dale Armstrong.
Aye.
Jesus Dominguez.
Aye.
Daniel Drummer. Daniel Drummer is absent. Katarina Ellaby.
Aye.
Jonathan Irvin. Jonathan Irvin.
Aye.
Tanya McMillian.
Aye.
6-0, motion carried.
Thank you. Okay, and so that is it for the ledge report. But I would like to give the public, if there's any in attendance, an opportunity to make a public comment on the ledge report. So moderator, will you please facilitate public comment on agenda item number 11, ledge report?
Public comment is now open. Please type comment into the question and answer box and send it to all panelists and unmute your mic when prompted. Seeing no comments, would you like me to close the option?
Yes, please. Thank you. And thank you, Brooke, for that presentation. Just want to comment that, sometimes I see there are no attendees, and sometimes I see there are some, and so out of an abundance of caution, I'll always ask for public comment. So We're going to tackle agenda item number 12 after our lunch break, which is going to be at 1:30 when we come back, right?
I think we can do the report portion of the rulemaking report and just hold the proposed aside.
Okay, and which one is?
So 12A?
Do 12A and hold off for B and C?
Correct.
Okay. All right, so let's do agenda item 12A, and then we'll hold B and C for after we come back from lunch.
So there are currently 6 rulemaking packages on the board's rulemaking calendar, which is submitted to the Office of Administrative Law each year, and this helps them determine rulemaking workload. The disciplinary guidelines were approved by agency on June 30th, and the notice was filed with OAL on July 2nd. The 45-day public comment period commenced on August 31st, and there were no public comments received. No public hearing was requested. So we are currently working on the final rulemaking package, which will be submitted to DCA Legal for their review shortly. There is no update on the coursework tool and performance evaluation tool regulations. We are still working on putting together that initial phase review rulemaking package together. So those will be forwarded to DCA Legal soon for their initial phase review.
Sorry, can you help me understand where we are in this package? I heard exactly what you just said, but help me understand what exactly needs to happen for it to go forward.
So the initial package includes doing the initial statement of reasons, the proposed language. We'll have to notice it, and now that it needs to go to agency for additional review, it does have to go first to DCA exec and legal, and then it'll go to agency for their review, and then it'll be noticed. So again, it's in the initial phase review. It's about 4 steps along. It still has quite a bit of ways to go. So staff are putting together the initial rulemaking package, which is the initial statement of reasons, the notice, the proposed language, and any incorporated documents of reference as well.
And was your question pertaining to the Coursework Tool 6 regulation or the model guidelines?
This question was to the coursework tool, but I guess I still don't quite understand, because it here says submitted to DCA, right? For initial phase review, but then there's still work that staff has to do.
Right.
Okay.
And I think that's kind of what's missing sometimes in the rulemaking report here. It doesn't show all the back and forth that goes on between DCA legal and staff. So there's quite a bit of back and forth on not only the initial statement of reasons, but on the language once it's approved by the board and just the overall package. So I know kind of the steps in here. It looks like it's been with DCA Legal since 9/2020, but that's not really, it's not showing the back and forth that has gone on between staff.
Okay, so I think, Jason, you're probably reading me right now, but I guess I'm looking at 4 boxes for this coursework tool, and I'm looking at dates, right? And so just trying to understand the timeline process, and I know we talked about this a little bit our last meeting as well. So help me understand. I don't know if board members also have questions. Yes.
Where we are right now is essentially the board has adopted the proposed language. But behind that proposed language are a number of supportive documents, like the initial statement of reasons, which essentially kind of maps out the story as to why the changes are being made down to the very detail. Like if you're adding coursework tool 6 and you're keeping 1 through 5, why? And providing that rationale, not only just for us with biases who understand why, but for the layperson, a stakeholder, a legislator, an OAL attorney, so on and so forth. So that part is still being worked on between board staff and the counsel from the DCA Reg Unit. The ISR, a fiscal impact analysis, all these kind of things that are part of the rulemaking package. So for the coursework tool, the majority of the work for the board itself to do as members is done. Yes. You've adopted that language and it's ready to go. Part of the delay in the dates, we've discussed at length over a number of different meetings and talking about implementing improvements, and we've seen some improvements, but we also have, I won't say too many. Well, yeah, well, we have too many reg packages in the hopper at one time. And so all of staff's attention is kind of divided amongst those packages. So the same staff that are working on coursework 206, working with DCA's reg unit, is also trying to finalize and finish the model guidelines. Is also trying to finalize and finish 2138 regs and those kind of things. So I think you have two pretty significant reg packages that are about to just make their way through the hopper and be off this calendar altogether and get implemented in law. Hoorah! And once that happens, you'll see that a much more rapid acceleration for those existing packages. Again, for the coursework 206, board members' work is done. You've adopted the language. It now needs to go out publicly noticed for public comment. As a result of that public comment, it may come back to the board to address some of those issues. We may have to amend language. Hopefully that's not the case. But once we file it with the OL for the first time and we get that public notice section out, you'll start to see it move the same way the model guidelines have moved, the 2138 regs have moved. That explanation goes for the next package too, which is the performance evaluation tool being included, as well as the CPI, or the performance instrument. They're somewhat in the same state. We're just preparing those ISRs, determining if there's any kind of fiscal impact. All of those things behind the scenes involve not just DCA's reg unit and BTBC staff, but also the budget office and the Department of Finance. We have to tell them, you know, whatever this reg is it going to have a fiscal impact? How much? How is it going to affect? Is it worth having? And really wait for them to kind of sign off on their buy-in before we move it to the next process. We used to have a more fragmented kind of approach where we could move some of these things forward without all of the intricacies, all of the details addressed, like a 399 or a fiscal impact form, or forms incorporated by reference, or those kind of things. Now the reviews really have to be whole cloth reviews. They want to see a whole package from us before they actually send it to agency for that agency review. And that creates some difficulties, because some of these things where they used to be part of a latter stage of the process are now, much earlier in the phase, especially that impact statement for finance. And so we're still kind of getting used to the sequencing of events and how much review is actually happening by DCA, prepping for agency review, and then on to OAL. And it's a learning experience. It is somewhat irregular, but I think it will become regular over time.
Thank you. And thank you for the hope that once a couple get through, the others might go through a little more quickly.
No, that's not hope. That's the expectation.
Okay.
I mean, it's just like we were talking about in the DFI report, when you see a certain number of cases get spread under a certain definitive number of analysts, you can overload analysts. I'm lightening the load for the regulatory analysts involved, both my staff and DCA's reg unit. I would expect to see a higher level of performance once there's not as many cases traveling across their desk.
Specifically assigned to our board. Okay. So a question I really want to know, and I think we've been trying to answer this the last couple of meetings, and what's the measuring stick? In the past, before we had a reg unit, how long would it take in general to get a regulation to go through? And now we got a reg unit, and now it's taking a long time for regulations to go through. So I just don't want to make too harsh of a judgment without being properly informed on how long should the board expect for the regs to go through, because the date on this coursework tool package, 5/25/2017. This is September 16th, 2021. I don't know if that's expected.
So, as a tenured member,
yeah,
you have you have a remembrance of the way things used to be, if you will. So, the dates are a little bit misleading. I don't want to, say the sky is falling because the package was 5/17. The package was 5/17 because that's the first time that we actually added this to the rulemaking calendar as a consideration for progress. So there's a couple things in play. And I want to make sure that we're clear that it's not just the addition of a regulatory unit, but there was a retrieval of an authority we used to have when it came to approval on regs, where agency had actually opted out and said, we're going to leave that delegation to the department, and as long as the department wants to go through, we will reserve our review until the final step of the regulatory process. And a few years ago, they pulled that back. For whatever reason, they wanted to be able to provide review of those regulatory packages incrementally throughout the process, starting very early on. That did create issue as far as delay, and that's why I say as a tenured member, you have a remembrance, and as well as mine, that a regulation could be typically written and put into effect with anywhere between a year and a year and a half. I think we're learning now with the addition, so there's a couple contributing factors. With the addition of that additional review, or at least earlier preliminary reviews by agency, the addition of the regulatory unit and kind of feeling our way around in the dark and how that's going to work. COVID is the situation with some of those kind of things, and just my own limited resources with staff and accommodation, because part of that is us. We have to bear that responsibility as well. Moving forward in the future, your specific question is like, what's the waterline? What's the measurement? What can we expect as a duration of time that a typical regulatory package should take? I do not know. We used to be able to map that out. In fact, we had documentation that we provided that this is the expectation for this stage of review. This is the expectation for this stage of the review. I think we have that to a certain extent. I just don't know how accurate it is in reality right now. And it's something that we're asking for kind of on a regular basis to be provided with. And like I said, that analogy of kind of feeling our way around in the dark, as we become more familiar with the process and where the reviews occur, even this example of incorporating documents by reference before we could review a package at all. Like, I don't want to see that until the 399 is done. I don't want to see the document for review until you have a complete package. It makes it that much more difficult to try and get it reviewed that much earlier in the process. So as a learning experience, I think that we're finding, we know we have to have these things in advance. The problem with that is some of those things work themselves out through the process itself, which can also create difficulties. We can identify that there's no fiscal impact. And you might find that a simple change in law or interpretation of law by somebody at the Department of Finance disagrees, and it just sets us back a little bit more in our ability to provide that documentation for review up to the level of agency. I am optimistic, and I wasn't this time last year. I was a little disappointed in the performance of what we were doing myself. The model guidelines and the AB 2138 regs are an example of, maybe proving me wrong. Now that they're almost to completion, there's a part of me that would have expected it to be so, but there was also a part of me that thought they would never get done. And so, I don't want to be too pessimistic. I want to make sure that we get these things done in a timely manner. And I think with the PET and also the coursework tool 6, they're very simple regs in my opinion. There's just the addition of a particular document. The story is very easy to tell. It's not going to have any more fiscal impact than it was when we imposed the coursework tools 1 through 5, those kind of things. Getting everybody on the same page can be difficult. Telling that story so everybody understands it means basically teaching them the whole history of that particular item. But I think we're making headway. I think you'll see we'll have a 15-day, a 45-day comment period on both of those packages fairly soon.
Good. And I mean, I don't know. I guess I would really love to invite someone from the reg unit to come and give the board a presentation. And just allow us to absorb the information and have realistic expectations so that, you know, we know when we see dates on this, you know, flow chart here, that we shouldn't raise our eyebrows. Oh, well, that's expected, you know. So any education that you can give us in the future would be much appreciated. Because it's easy to jump to conclusions when you just look at the flow chart.
We can certainly request a presentation of services from the DCA reg unit. For their convenience, I would recommend that we do it when we're in-house in Sacramento as opposed to traveling. Our next December meeting happens to be our first in-person meeting in Sacramento, so I can definitely make that request.
Thank you, that's great. And my apologies to the other board members for speaking all this time. Any comments or questions from you? Dr. Dominguez, Ms. Ellaby, Ms. McMillan?
Madam President, this is Jesus. I completely agree with you. But just so I personally don't feel like we're proposing these regs for the grandchildren of the people of California, that would be great.
Thank you.
Yeah, I appreciate the conversation, so no apologies needed here.
Thank you. Okay. Brooke, shall I allow you to continue?
Please. Piggybacking off of what Jason said earlier, I'm so pleased to report that the substantial relationship criteria AB 2138 package is very close to being approved by OAL. The final rulemaking package was submitted to OAL for approval on June 29th, and they do have until December 9th to approve or deny it. So currently we're waiting on approval of the 399, the fiscal impact statement from the Department of Finance. And once OAL has that, the regulation will officially be amended. In addition, we did ask for a justification to OAL for it to become effective upon filing with the Secretary of State. So that was submitted instead of having to wait until the normal processing timeline of January 1st. We do have a processing timeline I included in the meeting materials. It shows that if you submit a regulation between a certain time, sometimes it takes 2 to 3 months for it to take effect. So we did put forth a justification asking for it to become effective upon when it is filed. So it will be done hopefully sooner than January 1st. Moving on to the retired license regulation, we will be looking at proposed language under agenda item 12C after lunch. And for the continuing competency regulations, we are still researching in the research stages for those, and we do anticipate bringing proposed language to the board hopefully soon at a future meeting date.
Fantastic.
Just to add to that last tidbit about the 2138 regs, I mean, we were anticipating there was a possibility that those rules would actually be in effect today, right? So, and we could get notice at any time at this point. So, as soon as the Department of Finance okays that minimal fiscal impact or non-existent fiscal impact, and OAL writes that approval, as soon as the Secretary of State receives it and chapters it, the law goes into effect. We don't have to wait for that quarterly data publication. And that will be our first successful rulemaking package in years. So we can't wait.
How many years?
It's probably 7 or 8 years by now.
No.
I think the last one was 2015, right, for the fee increase English proficiency.
Yeah, we did a fee increase and then the TOEFL.
Yeah. Okay. All right. we are going to take B and C after lunch. What about D? Discussion and possible board action regarding definitions and license status definitions?
We are not prepared to present that today.
Okay.
In our kind of conversations going back and forth with the reg unit, it turned out to be a little bit bigger of a package than we anticipated. So we'll be bringing it forth at a later date.
So we will table D.
Mm-hmm.
Okay, 12D. And so one more opportunity for board member comments or board member question or discussion. And if we could please have the moderator facilitate public comment on agenda item 12, rulemaking report.
We are now open for public comment. If you would like to make a comment, please type comment in the Q&A box and unmute your mic when prompted. Oh, and please send your comment to all panelists or participants. Seeing no comments, would you like me to close the option?
Yes, please, thank you. All right, it looks like we were pretty timely. Thank you everyone for holding your hunger. It is 12:28 and we will resume at 1:30.